Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. The Honorable Apex Court, 3 judges bench. Honorable Justice or Chief Justice of India Dr. D.Y. Chandrachud, J.B. Pardiwala and Justice Manoj Mishra. While dealing with the case of reappointment of Vice Chancellor of Kannur University, Kerala State, that is, in the case of Dr. Prem Chandran Kuzooth. Prem Chandran Kuzooth. Kuzooth spelling will be Keezhoth. And another versus the Chancellor Kannur University and others. In Civil Appeal number 7700 by 2023, dated 30th November 2003, quashed the reappointment of the Vice Chancellor of the Kannur University. Actually, in the name of the Governor of Kerala, the CM and other statutory authorities, they have passed the reappointment order. No doubt it is in the name of the Governor, but Governor did not act personally. This is the major difference. Normally, we are all under the impression that as per Article 161 of the Constitution of India, we all know that there will be a chief minister to the state and he will be having a council of ministers. The council of ministers will aid the governor in the administration of the state. But in this particular incident, as a chancellor, he is not a titular head. He has to use his option personally, not as the so-called as per the dicta of the Chancellor, the Vice and CM and others. This is what happened in this particular case. Honorable Supreme Court of India quashed the appointment. This has come in Hindu. Right. Mr. Gopinath Ravindran, he was appointed as the Vice Chancellor of Kannur University in the year 2017. For 4 years he will be there. His term expired by 2021. The problem started then. So please remember, in the reappointment, please remember, so the abdication or surrender of the statutory powers by the Chancellor are observed. Justice Pardiwala, why he has stated like this? Please remember, the Chief Minister and the Higher Education Minister, they had kick-started the reappointment process and not the Governor. No doubt, in the name of the Governor. So now, the subordinate law and supreme law, yes, definitely, they will come into conflict. Right? Now, Honorable Supreme Court of India clearly held that under the UGC Act 1996 and other statutes, the Chancellor plays a very important role. Please remember, he is not merely a titular head, just title. Titular head means just de jure. But in the selection of Vice Chancellor, he is the sole judge. And his opinion is final in all respects. So he did not go by the advice of the Chief Minister. In reappointing the Vice Chancellor, the main consideration is, please remember, the interest of the university. So he has to give the orders. In his name, the Chief Minister and other officers, they have given the reappointment. It is not correct. That is what the Honorable Court has stated. So the Chancellor's powers, particularly reappointment or appointment of the Vice Chancellor, they have to be exercised solely in the interest of the university. And please remember, the Chancellor has to assume the role of a judge in this case. So it was held in this case that though by virtue of office as Governor, he became Chairman of the university, but while discharging the functions, he did not perform any duty or exercise any power of the office. He did not act independently. He did not act individually. This is what is commented by the Honorable Supreme Court of India. The statutes makes a clear-cut distinction between two distinct authorities, that is Chancellor of a university and the State Department. Why specifically the distinction was made? Please remember, the governor as Chancellor, please remember, will act in his personal capacity. The powers and duties performed by him under a statute as Chancellor, it has no relation to the so-called aid and advice of the ministerial authorities or government. Of course, as a result of which, the appointment of it was confirmed by the High Court also in the year 2021. Immediately, this Prem Chandran, he went to the High Court. High Court has confirmed the reappointment, but now the reappointment stands question since the appeal is allowed. Of course, in a dignified manner, Dr. V.Raveendran, he says, I accept the Honorable Court's decision to set aside my reappointment. He says the reappointment was not done at his request. It was made for political gains. He said, Supreme Court cancelled the reappointment. There is no need for him to resign. He will simply demit the office on a particular day. So, here, very good decision by the Honorable Supreme Court of India. The important point is, as Chancellor of the University, the Governor should exercise his personal thing, not the statutory thing. Right? He need not be guided by the Chief Minister. As per 161. 161 is regarding administration. This is as per UGC Act. So now Central Act and State Act. So when both acts are there, doctrine of repugnancy, definitely the Central Act will take more precedence. Right? So if you understand this much, it is sufficient. Thank you.